morning, everyone. My name is Jie Huang. I'm an immigration attorney at Scott Legal PC. So today we are going to spend some time talking about a topic of high interest from E-2 visa clients, which is what are some of the pathways E-2 visa holders can explore to get a green card, permanent resident status in the United States. As many of you know, Scott Legal was founded on an E-2 visa, and we specialize in immigration options for entrepreneurs and investors. So a few things before we get started. Scott Legal is a full-service immigration law firm. Our main specialty is E-2 visas, and we regularly process a high number of them. But we do assist individuals pursuing various types of visas, including family-based, employment-based, and we also help entrepreneurs pursue green card applications in various categories. We will be continuing these webinar series, doing at least 2 webinars a month on different immigration law topics. At the end of this webinar, we will be sending out to the participants a few things. First, a PowerPoint that has all the information that will be covered in this webinar. Second, we will be sending you a comprehensive guide covering all the visa categories that we discuss in this webinar that you can use as a reference. We can also send you a link to where you can sign up for additional webinars in the future, and also a link to this webinar as it will be recorded. This webinar will be available on YouTube, and we encourage you to subscribe to our YouTube channel and hit the notification button as we regularly upload immigration videos on a variety of topics. Finally, we will send you a link where you can set up a consultation if you would like to discuss more specifics on your case. Okay, so today we are lucky to have Ian Scott, president and the founder of the firm with a wealth of E-2 visa experience, who is an entrepreneur himself, currently on an E-2 visa. And he has been helping a variety of entrepreneurs and investors pursue green cards, who will be answering these commonly found questions regarding possible green card pathways for those on an E-2 visa. And finally, for any questions you may have, please feel free to add them to the chat box or to the Q&A function, and we will try and get to all questions. So without further delay, let us move into our questions. All right, Ian, good morning.
Good morning. Thank you very much. Great to be here, Jay.
Yeah, so just as a quick introduction and to bring everyone up to speed on E-2s, could you describe a little bit what is an E-2 visa?
Absolutely. And an E-2 visa, as you mentioned, it's kind of near and dear to my heart because I am in the US on an E-2 visa. In fact, the law firm was founded on an E-2 visa. So I'll use the law firm as an example to describe, what an E-2 visa is. An E-2 visa is available to individuals from certain countries. So I'm Canadian, so I'm one of the countries that's on the list, but there are 80 or so countries that are on the list, and they are countries in every continent except Antarctica. If you once you're a national of the treaty country, and national means having a passport from that treaty country, then what the idea would be is that you invest in a business in the United States. So the investment can be purchasing a business, or the investment can be starting a business. And there is no set investment amount, but generally speaking, we like to see investments of 100,000 plus, but we have done investments, much smaller investments for consulting companies. And in fact, the law firm is a consulting company. We offer legal services. And our investment amount was $15,000 that we spent, and then had some money set aside in a business bank account, about $35,000 in a business bank account that was just kind of, we described it as working capital. Those are very, very, very risky cases, but we tend to specialize in risky cases and cases with risk, whether they're low dollar amounts or have other risk factors. So the investment amount is one part of the E-2 visa. Another significant part is that the business has to be set up such that it is going to be able to hire U.S. workers. So we generally say that after a 3-year period, we'd want to see the equivalent of, after a 5-year period, we want to see the equivalent of 3 full-time workers. So not 3 years and 5, but better, it's better, right? So within
Right.
5 years, 3. So, and like I said, when I say equivalent of full-time, it could be various part-time, etc., or just 3 full-time people. So you don't have to have employees on day one. although it's helpful to have employees on day one. You don't have to have employees on day one, but you would put together, if you were starting a business, you would put together a business plan that would show that the business is viable and that you are going to be able to hire US workers over a period of time. And the other kind of maybe key element that I'll throw out with an E2 visa is that an E2 visa is not, you don't apply for an E2 visa just when you have a thought of starting a business. But when you apply for the E2 visa, your business doors are almost ready to be opened, right? So you've spent the money, like you have a lease, you have a business entity set up, you have a bank account set up, you've purchased equipment, you've spent money on marketing, different things like that. So, this isn't a visa for someone who just intends to start a business, and you're showing the government all of the things related to the intention to start a business. There are some visas like that, but just not this one. But it is really you're applying for the visa once everything has been done, and that's a little, it's an aspect that is, I think, difficult for some people because they have to spend the money and do a number of different things before they actually get the visa. But it's just unfortunately the nature of this visa. But that being said, the visa has very, very high approval rates. Past results don't predict future outcome, but our approval rate is around the 98% mark. And even the overall E2 visa approval rates are over 80%. So those take into account people who, aren't familiar with E2s and difficult consulates and all of the other aspects. But even that approval rate is over 80%. So even though the government is requiring you to do quite a bit before you even apply for the E2 visa, the approval rates are on the high side. So.
Right. And we did have a question pop up on the Q&A box right here. And for the E2 visa, any type of business really can qualify, right? What if the person wants to do a home renovation kind of business?
Sure. So it's true. Any type of business can qualify except a business that is not legal under federal law. So I say that because it sounds obvious. Well, it has to be a legal business, but like, let's say somebody, for example, wants to set up a cannabis shop in Colorado, and Colorado, selling cannabis is legal. But unfortunately, that particular business wouldn't work because immigration is governed under federal law, and that's what that's what they would look at. So, but in terms of a home renovation business, absolutely, that would be, we've done many E2 visas for home renovation businesses. And what people do in those, businesses, they purchase tools, they purchase equipment, they get the license. That's very important to have a license. Usually you're paying the local jurisdiction some type of a fee and getting a license and really getting everything that's required for that business up and running. You may have, contractors in line, because if you have plumbers and other people, electricians and things like that, like contracts signed with them, that might be all of those in line. But absolutely, home renovation businesses, that's something that we've done many of, and they can make great E2 visas.
Great. Okay, so now let's move on to the main topic of today's presentation, which is why would some people want to move from E2 visas to a green card?
Yeah, so I guess that the one thing with an E2 visa is that it is a non-immigrant visa. So it is a visa that allows someone to live and work in the United States indefinitely, and it does afford an individual with a lot of privileges, a lot of things that citizens and green card holders can do. For example, you can buy property, you can get a mortgage, you can get most types of loans if you need them. Your children can go to school in the United States. All of those, public school and private school in the United States. So all of those benefits. However, if you have a green card or you become citizen, you have more benefits, right? So there may be certain programs, university or college programs, that offer scholarships only to green card holders and citizens. There are certain loans that are only available to green card holders and citizens, like SBA loans. There are certain types of small business loans that are only available for the most part, only available to green card holders and citizens. You have to be a citizen to vote. Voting is very important to many people, and you can't do that. And then finally, green card holder is the step to becoming a citizen. The first step to becoming a citizen And if the only time that someone cannot be deported from the United States is if there's actually a citizen, right? So any other category, even a green card, an individual can be deported. So I think that the security, if someone has made the decision to make their life in the United States, then there's a certain amount of security that might be associated with so a certain amount of security associated with actually obtaining the green card and then citizenship. Now, then the final thing that's very relevant to E2s is for the individuals. I'm an E2 visa holder and I have 2 children, but my children happen to be US citizens because they were born in the United States. However, we have many E2 visa holders that have children that are the same nationality as them or other nationalities that are not American. And they can only hold the E2 visa until they turn 21. So once they turn 21, they have to find some other type of visa to move to, whether it's a student visa or some other type of visa. And it is difficult because we do have situations where the 21-year-old doesn't want to go to school, and then there's no other visa available to them. And there are instances where there's kind of family separation as a result of that. So if the individual is on an E2, and the child is not 21 yet, and the principal applicant or the spouse of the principal applicant gets a green card, then all of the family joins in that process. All the children under 21 and the spouse join in that process. So that's another big reason we see people moving to green cards from an E2.
Right, I see. Those are very important considerations for sure. Right. So, as an overview, then, how does the green card system in the US work? And in particular, is there like a point-based system for awarding green cards or selecting green card applicants? How does that work?
Yeah, it's a great question. And the system in the United States is very different from many systems around the world, and it's certainly different from the system in Canada, where my E2 visa is based on being Canadian. Certainly different from that system. And a lot of countries in the world have a system where it's a points-based system. So the individual can gain points for a number of different objective factors, right? So education that they have, university or college degrees, their ability to speak the language in the primary language or the official languages in the country. Like in Canada, there are 2 official languages, French and English. So you get points for being fluent in one of those 2 languages. Your age, governments will assign benefit to people who are younger based on their longer ability to pay taxes into the system and things like that. Your work experience, whether you have a job offer or not. So lots of different factors. And another big one is the time that you've been in the country, right? So we have people in the United States who have been to school here. I've been in the United States over 20 years and I don't have a green card. So they'll assign factors based on based on these objective criteria and give you points for all of those factors. And then when you hit a certain number of points, bingo, you get a green card, right? Like some type of permanent residency. Because a green card, it's called a green card because it, used to be green. It may still be green kind of, but it used to be green. But it's just a permanent resident card, right? So every country has a version of a permanent resident card, which is the first step from to moving to some type of citizenship with that particular country. So now the United States doesn't have that type of points-based system. Instead, what they have is just a list of green card categories, and if you're eligible for a particular green card category, you can apply for it. And none of the green card categories take into account any of the things that I just mentioned in terms of a points-based system. They just might be parts of the application process, right? Like in terms of certain green cards categories, you may need a degree for, or something like that. But really what the way they're broken out is they're broken out for the most part, family-based categories, green card categories, and then employment-based green card categories. And a lot of the categories we're going to talk about today in terms of how people move from E2 to a green card, they're within one of those 2 broad bases, either family-based or employment-based. And I think a key thing, based on what I just described, kind of one key thing to keep in mind is that a lot of people, because they're used to these points-based systems in their own countries, they're often coming to us asking, does an E2 lead to a green card, or does any non-immigrant visa or any visa that you can get lead to a green card? And the clear answer is no, there aren't any visas that lead to a green card. Instead, you can be on any visa, or you can be outside of the United States, not even on a visa, and you can apply for any of the green card categories that we're talking about, that we're going to talk about. Yeah, the fact that you have a particular non-immigrant visa, in this case, let's say the fact that you have an E2 visa, or even if someone was on an L1 or H1B or TN or whatever type of visa that they were on, the fact that they have that visa is it's irrelevant for the purposes of determining their eligibility for a green card, because you're going to be looking at the green card category and assessing whether or not they're eligible, whether they're eligible based on that particular category.
Yeah, very, very important distinction for sure. And if there is a take-home point, then there is no visa that automatically leads to a green card, which is a common misconception. Right. So let's move on then and talk about some specific green card categories, permanent residency application categories. So in family-based categories, what are some of the common types that we see when people are moving from an E2 to a green card?
Yeah, absolutely. So on the family-based categories, one, kind of surefire, easy way, and one that we often see is someone on an E2 and they marry a US citizen, right? So that is a category that is, we're going to talk a little bit about backlogs, but it's going to be the fastest green card category, in the sense of there are never any backlogs with respect to that particular category. When I say fast, it's still going to be a long time, like 18 months or something like that, but just it's not going to be 14 or 15 years. So that's one way we see. Another, and the way that the family-based category works is that there are kind of two categories. One is what's called immediate relative. And immediate relative isn't the way we think of immediate relatives. It's defined by law. So immediate relative means your spouse, or if you're a US citizen that is 21 years of age or older and you want to sponsor your parent, right? That's what is an immediate relative. It's not your sibling, or it's not a parent sponsoring a child over 21. It's just it's those categories that I just mentioned. And then the other category under family-based is what's called a preference-based category. And the preference-based categories are broken out just F1 through F5, but they're just categories that are defined. So in order to understand them, you would just go to the preference-based categories and look to see what they are. But one, for example, is US citizen that wants to sponsor their sibling. Right. So that's an ability. There's an ability to sponsor your sibling if you are a US citizen. Now, that brings us to an interesting, kind of topic, though, is that for this category and most of the other categories that we're going to talk about, sometimes there's what's called a backlog, because what happens with the way that green cards are issued is that for the family-based, in every category except the immediate relative categories, there are only a certain number of visas or green cards. Visa and green card are used interchangeably, that can be issued every year. And so then once those green cards have been used up, then people start to go on waiting lists. So for example, for the US citizen who wants to sponsor their sibling, there are only a certain number that can be issued each year. And so over the years, it's been used up. So now the backlog is a 15-year backlog, right? So if someone wanted to sponsor their brother or sister for a green card and they were a US citizen, they could certainly do it, but the green card wouldn't be available for 15 years. So there'd be quite a long wait. And the person isn't afforded any benefit during that wait period. Now, not every category is delayed. Not every category is delayed, but a lot of the categories are under the family-based category. So the first kind of question would be, are you eligible under one of the preference categories? So let's say there was an E-2 visa holder that, kind of had a parent that was a US citizen or something like that. So then we say, are they eligible? And say, okay, yes, they're eligible. Then we have to go to another schedule to see how long the wait is, right? So the parent that is sponsoring a US citizen over 21, the wait might be 7 years or some period of time like that. So that's kind of how it works under the preference-based category. So, but we do have individuals who kind of move from E2 to green cards based on family categories. We had one individual that his mother was a green card holder, and the mother was a US citizen. The mother had filed for his green card years before. So he applied for the E2, and there was only 2 years or so left that he had to wait before his green card category was current. And there are some risks with that, because sometimes they won't issue the E2 when that happens. But in this case, they did issue the E2 for 5 years. So then he got the E2, came to the United States, worked on the E2 for the 2 years. But then after the 2 years, he was eligible to adjust status or get the green card, because now his green card category was current, and he has a green card today based on that. So we definitely do see that. Now, the other thing I just wanted to talk about, and this is going to apply to all green card categories, but it's worth talking about just in the family-based area, is that there are kind of 2 ways to apply for a green card. One way is if you're in the United States. So if you're in the United States, you have 2 options, right? One option is that you do something called adjusting status. When you adjust status, you file paperwork within the United States. You have to be in the United States. If you file adjustment status paperwork, you file paperwork. And when you do that, you can file additional paperwork, which basically allows you to work after that petition has been approved and allows you to travel after that petition has been approved. Now, the downside of this, filing this adjustment of status is your category has to be current. So what we just talked about before, if your category is not current, then you can't file the adjustment of status paperwork. But B, the other kind of downside is that once you file the adjustment of status paperwork, you have to stay in the United States until your travel authorization has been approved, and that could take a year. So it could even take longer. So that travel authorization has been taking a long time, and you can't leave, because if you leave, you've in essence abandoned the I-485, the adjustment of status applications. There's some rare exceptions, but we won't get into those in this webinar. But so that's the one option, is that someone that's in the United States. Now, the person in the United States can also decide to, let's say they feel that they don't have the ability to stay in the US. They could also decide that they want to consular process, right? So they could do the visa at the consulate. And then what they're doing in that case then is they have some other underlying basis for staying in the United States. So it could be, they're just on an E2 and they have an underlying basis to stay in the United States and leave and enter based on the E2. Now, that it's a good segue into the other option, is that when people apply for a green card, and not as relevant to this because we're talking about E2s to green card, but when people are applying for a green card, if they're outside of the United States as well, they can apply just through consular processing. When you're just as a general aside, there's no need to be in the United States when you're applying for a green card. You could have an individual that has never stepped foot in the United States and apply for a green card based on a family-based category or an employment-based category. There's no requirement. We're going to move to employment, I believe, next, but even in employment-based categories, there's no requirement that anyone ever worked for a company before they get sponsored for a green card. So.
Right. And I think you also mentioned this briefly, but how can someone work while their green card application is pending? And by that, I think I mean the adjustment of status application.
Yeah, absolutely. So there are 2 bases that someone could work. So if you're on an E2 and you apply for an adjustment of status, while you are waiting, and let's say you haven't left the country, your travel authorization hasn't been approved yet, while you're waiting, you're still in E2 status. So you're able to work just based on the fact that you continue to be in E2 status, as long as your underlying E2 status is still valid. You have a valid I-94 and things like that. Or when you file the I-485, you're also filing an employment authorization document. So that document, it could be approved anywhere from 3 months to a year. We've seen kind of varying degrees of timing with respect to approval. So let's say that someone was on an E-2 and their status was expiring, their I-94 was expiring or something, then they would require that employment authorization to be able to continue working. But because the filing of the I-485 allows you to stay in the U.S., but because you're in a period of authorized stay once it's been filed. However, you do always need some underlying basis to work if you are working. So that could be the basis you had under the E-2, or it could be the basis for the employment authorization that you have obtained.
Right. So you mentioned a little earlier that there were employment-based green card options, right? So which green card category, in your opinion, is the most popular when someone wants to move to a green card from an E-2 visa?
Yeah, I think it's a bit of a toss up, but I think I'll go with we are doing a lot of green card people moving from E-2 to green card through the national interest waiver category, and this is a category. It's under the employment-based categories fall from EB1 through EB5, and this one falls under EB2. And EB2, it's a little bit confusing. I don't know why they just didn't make a completely separate category for this, but EB2 is a little bit confusing because it's broken out into two categories. One is national interest waiver, and one is just kind of, I'll describe it as company sponsoring you for a green card. But the
Right.
national interest waiver, the reason it's appealing for E-2 holders is because there was a case that was an appeals case that was decided in 2016. And this particular case, the name of the case is called Danisar. You'll hear it all the time when you hear national interest waiver. And this case really opened up the ability to apply for the green card for entrepreneurs, because there was kind of specific reference in the case to this. And so this is the category I think that we see, most of our E-2 clients using to move to a green card. Sometimes, and what this requires is that the individual has some type of endeavor that they say that they're coming to the United States to do, and this particular endeavor has to have national importance or substantial merit. So in essence, that the particular endeavor has to be important to the U.S. government. So we could argue that what's important to the U.S. government is job creation. So if you have some type of enterprise that has the ability to create many jobs. It could be some type of economic impact. It could be some government, and let's say the business has to do with some government initiative that the government has said that they find important. That could work as well. There's a great appeals case as well that deals with an individual who was starting the case says a number of times, they say small consulting company. So it wasn't a company that was a large company or meant to kind of expand all over the United States, but it was described as, and the way the cases are worded is that every word for lawyers is important, right? So when they use small, like when they kept on saying it in the case, right? So but what it was is he opening up a company that was providing services to vets and reintegration into society and things like that. And what's interesting about this case is initially the USCIS, it was submitted to them and they said, nope, not good enough, right? And they denied the case. And then it went to the appeals board, and the appeals board said, no, absolutely, this qualifies. And they went through all of the criteria. They said, well, it's national importance because the government says it's important, right? It says that, the reintegration of integration of people into the society and providing services for them is important. And I think that I didn't see the reason it was denied before, but I think that part of the reason it was denied is probably because initially the examiner saw it as, oh, well, it's a consulting company, but it's only going to be reaching X number of people and it's not going to be big enough or whatever. But it seems that Danisar, because it has other wording in Danisar that kind of talks about, well, the whole thing doesn't have to be your endeavor doesn't have to impact every state or whatever, right? So the appeals board really kind of looked at it and said, yeah, it meets the first criteria that there's national importance. The second criteria they looked at, and that's the entrepreneur is well positioned to advance the endeavor, and this person had contracts and had connections and had done similar things in the past, and had his company was capitalized, and he'd started an entity and a bunch of other things. So they said, yep, he's met the second criteria as well. And then for the third criteria, they're really looking at the reasons on balance why the government should waive the labor certification, because the other part of the EB2, the other EB2 section, the individuals required to get labor certification. And the labor certification process is a process where the government, Congress has said that in order to hire this particular person or get them a green card, you have to prove that the company can't find a qualified US person. And the Congress has also said that that's in the national interest, right? That protecting US jobs is in the national interest. So you have to kind of come up with arguments of why on balance they should waive the labor certification process. And what I find with that one is we're often using very similar arguments that we use in like prong 1 and prong 2, but then also throwing in other arguments of just why the person's exceptional. So we sometimes will go to some of the exceptional or extraordinary ability criteria and pull out other things, like if they've published things, or if other things the government has kind of said in other petitions to say that this makes a person exceptional, to kind of argue that, well, you should waive the labor certification process because this person's so great, the same way you do it when you under EB1, right? Like if they've met 3 of the criteria and things like that. So we've had great success with arguing Danisar, and Danisar really allows for a lot of creativity in petitions, and we've even seen some petitions. We were GA and I were on a call recently with someone, and they were describing a petition which the first description of the petition, I would have thought that would never have been something that would have been approved, because it was just a kind of someone who was making a documentary about a particular topic, and that was approved, right? And I could see after
Right.
I could see after, like, it's like, well, yeah, it actually does meet the criteria of Danisar, but I would have never thought that like if someone came to me during a consult and said, oh, I made this documentary and I want to apply for NIW, I would have thought, well, I think you might need a bit more than that. But this one actually was approved, and but I think what I love about the NIW is that it does allow you to kind of really utilize, like, say that here are the criteria, and kind of fit them into to what it is that the person's doing. So it allows for a lot of creativity. So they're definitely one of my favorite types of petitions. The other kind of thing with this particular petition is that there are kind of there's a threshold, there are threshold considerations when you're looking at it. So before we even get into the 3-prong test, the person, and this is for all EB2, but the person has to have either an advanced degree or equivalent. So advanced degree is a master's or higher. So a master's, PhD, that's advanced degree. Or equivalent. So equivalent, we're saying, is bachelor's degree plus 5 years of progressive work experience, or something called exceptional ability. So exceptional ability, there are a list of criteria. I think there's 7 or 8, and you have to meet at least 3 of them. But they're kind of, a lot of people come to us and they're like, oh, I qualify under national interest waiver because I think I meet 3 of the exceptional ability criteria, but we're like, sorry, that's just the threshold before we get, and once you, yeah, that's great that you meet the 3, but now we have to go to the hard stuff, the hard part of the, of whether or not, because let's say someone, for example, just had a high school degree and couldn't meet the exceptional ability criteria, and they, split the atom or created a life-saving virus, they wouldn't be able to qualify under this particular category because they don't meet the threshold issue of advanced degree,
Right.
bachelor's plus 5, or exceptional ability, right? That's the no matter how important it was to the US government, there may be another category that they could, extraordinary ability or something, who knows, but under this category, they wouldn't be eligible. So.
Right. Yeah, so there are some complicated eligibility criteria that really you should suss out before, thinking that you could be eligible.
Exactly.
We did have a quick question pop
Mhm.
up on the Q&A box on the NIW. So it's a hypothetical, right?
Mhm.
Somebody on E2 status running a used car retail store, a car dealership in Colorado.
Mhm.
This person has a master's degree, an MBA, and after that, they started this business. Now, what would be the analysis be like when we're thinking about would this business be in the national interest?
Yeah, so I think that the analysis would be, so the first part of the analysis is starting with what endeavor, because you already, like, the person already has the E2, but then when we're doing the NIW, a first step for us is always, what is the person's endeavor? What is it they're coming to the United States to do, or what will they do after they get the green card? So now if the answer to that question is they will run a used car dealership, right? Let's say that's the answer. Then the only way I think that we would be able to, that comes to mind anyway, that we would
Right.
be able to kind of utilize NIW would be if the plan was to start some type of chain to open up a bunch of used car dealerships, such that we could maybe make the argument that the benefit to the benefit to the nation is employment, right?
Right.
I think that that's the only thing that comes to mind. Like if there was something else with used cars that, you know, because we GA and I were doing a case where the person was a housing developer, right? But the argument that we were making for that case has a lot more to do with that he's creating housing in underserved areas, right? He's
Right.
developing housing in underserved areas. So that's more that, even though there will be employment, the big argument that we will use is he's creating in underserved areas, which we couldn't, I don't really know if we could use it for a car dealership, but but I think the only thing that jumps to mind would be if we could argue that you know that employment, you know, employment, and I think you'd need, you know, you'd want to have the current car dealership would probably, you'd probably want to have, you know, quite a few employees, and
Right.
then a business plan that demonstrates exactly how you plan to move to, you know, to this much larger success. Yeah.
Right. And I do think it would be important to, for example, if this dealership was located in an underserved area,
Yeah.
you could
Yeah.
also speak with government officials or agencies in that area and get a letter of support or things like that. That could help. But yes, that
That's a great
definitely a
point.
fact
Yeah. Yeah.
specific. Yeah, it's fact specific question, but yeah, not impossible. It could be difficult, but there could be creative options, creative ideas to get it there. Okay, so another issue with EB2 NIW is, can someone self-petition, right? Because in other employment-based categories, you do need a company to sponsor you, but what about the NIW?
Yeah, it's great. Yeah, that's the other great thing about NIW is that you can self-petition. So you don't need you know, and that's the great thing as well about, you know, someone E2 and doing this. They have a choice. Actually, they can either do it through their own E2 entity, right? So the E2 entity can be their petitioner, or, and sometimes we'll make the decision, they can do it, or they can petition themselves. And we'll often make the decision of how it is exactly we apply, based on some factors. But yeah, but it's great that it is a category where you can actually self-petition.
Right. Okay, so I think that's good for the NIW. Now let's move on to another very popular category. Many people actually confuse the E2 visas with what is called the $1 million green card, right? So could you perhaps talk a little bit about that, the $1 million green card, and how one might move from an E2 to that green card?
Perfect. Yeah. So this is, yeah, this is the kind of the toss up in terms of, you know, the other big category that we do a lot of, moving people from E2 to a green card that is called EB5. Now, the EB5 green card is one that it's similar to the E2 in that it's an investor visa, investor green card, and the individual is investing a certain amount of money in a business. However, the EB5 is a lot more specific with respect to the amounts and employment. So for the EB5, you do have to invest either 800,000 or 1,050,000 into a business, and you know, it doesn't have to be a new business. This is something that could have happened from 1990 and onwards. The statute calls it a new commercial enterprise, but then defines that as anything that was started after a date in 1990. I don't remember the exact date. And the difference between the 800,000 and the 1,050,000 is whether the business is in what's called a targeted employment area. And that's an area that either is 1.5 times the national, the unemployment rate is 1.5 times the national average, or it's in a rural area as defined by the local regulation. So if it's in a TEA, then it's going to be 800,000. If not, it's going to be 1,050,000. A lot of people a lot of our clients have moved from E2 to EB5 because they can use their E2 entity, and also their E2 investment that they made years ago, they can utilize. We just had an approval for an individual who runs a farm, and they had invested. We actually didn't do their E2. They did their E2 20 years ago. And we've only been around for 10 years, so they couldn't use us. They did it 20 years ago, but they'd been investing, at the time we filed, the investment amount was 500,000. So they'd been investing money over time, years. So over many years. We were able to add up that investment over time, and the EB5 application was approved. I think that one of the things that this is a very, very complicated. This is probably EB5 is one of the most complicated types of petitions. E2s are complicated enough, but EB5s are more complicated because the government is very, very particular with a lot of aspects of EB5. One being that the source of funds, and there is a source of funds analysis for E2, but it's multiplied by 100 for EB5. Like so even, just as a brief example for E2, let's say someone gets a loan and the security is their some asset portfolio that they have, and then that would be fine for E2. We would just show the loan was coming from a bank and say that it was secured by these assets. That would be fine for E2. But for EB5, what they would require is that now show us where you got the money to buy the securities, right? So it's just always more and longer and much more extensive. And doing a few they're called direct investment EB5. So people who have E2 or starting a business, and it's always a struggle with business owners because, we believe always that the business owner, the money is coming from a legitimate source, but I think that often people have a lot of trouble kind of understanding just how detailed the analysis from USCIS is. And because you're always starting with, if 800,000 was deposited into the business bank account, then we're going back to where did that 800,000 come from? And then because we're tracing it back each time. So, okay, well, there's a bank account. So now we have to show how did the money get accumulated into that particular bank account? And often people, they lose sight of that and just kind of say, well, I'm really wealthy and that's where I got the money from. But it doesn't work that way. You have to trace it back to, so it can't come from a bank account and you say, well, I'm just really wealthy. You have to say, okay, well, how did it get into that bank account? And not just description, but showing the money coming in. If you say you saved it over a period of time, then the government wants to see bank statements for years showing that you accumulated those funds over a period of time. And let's say that you're saying that there were your pay was being deposited, and then showing that your pay was being deposited from a particular company. So it's quite extensive. And then the other thing with moving to EB5 is from E2 is that not all of the expenses that can be included in an E2 can be included in EB5. So for example, we can't include legal fees in EB5 investment amounts. We have to be very careful. Like, let's say someone invests, let's say they start their own business, they invest $800,000. None of that can be paid back to them, right? So you can't, so you even have to worry about what salary the person's being paid or what distributions that are being made, because the 800,000 that you invest, none of it can come back to them, right? So you're often tracking very carefully, what has been spent, so that you don't have an issue later on. So as I said, the difference between E2 and EB5 is the investment amount. The one difference is the investment amount. And as I said, you can make the investment over time. So the 800,000 doesn't have to be kind of one. So let's say someone started an E2 in business 5 years ago, and they invested $200,000. Then they could, when they want to apply for EB5, invest another 600,000 in the business, and then utilize, then they'd have 800,000 together, provided all other things work in the petition. The other kind of thing to keep in mind is that The investment has to be your personal investment. So it's let's say that you start a business, an E2 business, and let's say the first year the E2 business makes $2 million profit, and then that profit is sitting in retained earnings. And then you say, okay, well, next year I spent, all that money. You can't say that's not investment. That's just money the business has earned. So the investment has to be from your, from your personal investment. So in order for that to count, you would have to pay it to yourself, pay taxes on it, and then reinvest it in the business. Which kind of gets complicated. So if you have a means to take it from other personal investment sources, that's much better. The other big difference between E2 and EB5 is E2, they're not specific in the regulations related to how many jobs have to be created, but EB5 is. It's 10 full-time jobs, and not part-time jobs, full-time jobs. And all people have to be US citizens or green card holders. So, very, very important. We had the same farm that I was talking about. We have to, when we do later, they're approved from the I-526, the main petition, but this particular petition, in 2 years after they get the green card, they have to show that they were able to hire the 10 full-time workers. And one big aspect is proving that those workers actually have the authority to work in the US. So I recall for that petition, we just sent in some sample. We weren't claiming that these jobs were the jobs for the 10, but we sent in some saying, okay, well, look, they already have 10 employees, right? But we were just kind of saying it in the sense of, because we didn't have to prove it at that point. And then we actually submitted some of the documentation for the individuals, like green cards that the employees had given to the employer and things like that. And some of them weren't legitimate, right? So
Wow.
it's and then at the point of filing the petition, the government's not going to care if your staff have given you fake ID, right? You have to you have to have gone through the I-9 verification process and make sure, because they'll check it at that point. They'll check that to make sure that the people are US citizens or green card holders, right? So it's a tough one, because especially in they're working in a farm, but I think it applies to everyone equally. You have to make sure that the people that you are hiring are US citizens or employees, and they have to be working at that location, because the reason you got the reduced, especially if you're doing a TEA, the reason that you got the reduced investment amount is because you said you were hiring people from that location. So that's something that is often lost on because like entrepreneurs, it's maybe get in the habit of thinking they can do whatever they want, but with these visas, it's there are rules you have to follow, and the process extends over years. EB5 petitions take 4 years to be adjudicated, just the I-526 petition, and then the I-829 petition, the removal of conditions, even takes longer, another 4 or 5. So you could be in that visa process for 10 plus years. So.
Right. So definitely that is a timing related consideration. If somebody is wanting to get a green card fast, the EB5 may not be the best option because it may take so long at this point.
Exactly. And the only kind of one recent change with the EB5 is that up until March of 2022, when you filed the I-526 petition, the petition that takes 4 years or so to be adjudicated, you couldn't file a concurrent adjustment of status application. So you were given the filing of the I-526 really gave you no benefit, to stay in the United States. However, that was changed in March so that now we can actually file I-485. So individuals, when they, just by virtue of filing this petition, if they're in the United States, can be in the United States for quite a long period of time, 4 years or so, just waiting for the petition to be approved and get work authorization. So this sometimes is important for E2 holders if they, let's say their endeavor is something else, they don't want to do the E2 business anymore or whatever, but sometimes because an E2 holder can, if the business is running well, they can just renew their E2. But yeah.
Right. Makes sense. Okay, so in the remaining time, I guess we can look at some of the other categories, other options for a green card that an E2 holder may have. So for example, one question we get is, can an E2 company sponsor the owner of or his or her family for a green card?
Yeah, this question comes on, up a lot, and the answer is a short one, a two letter no. So
Right.
yeah. So it's It's not permitted. Yeah,
Right.
the green card company sponsoring regulations have, very explicit question that asks about ownership of, and family members and things like that. And the idea is that if you're trying to prove to the government that you can hire a qualified US worker, the government assumes that you're not going to be objective if you're looking at yourself or your family members.
Right. And would there be any other green card options for E-2 visa holders?
Yeah, so there is one that we don't use that often, but sometimes a green card holder, sorry, E-2 visa holder might be eligible for EB1A extraordinary ability green card. There are 8 criteria that are listed, and when you look at those 8 criteria, sometimes people then you have to meet 3 of those 8 criteria, and then there's another analysis, but generally 3 of the 8 criteria, and sometimes people can qualify under that. And that's probably a good point to mention that with it's called EB1A extraordinary ability, but we do have webinars on all of these separate topics. So everything we've talked about, whether it's national interest waiver, EB5, extraordinary ability, there are webinars on those. So if whether they're on our YouTube channel already from past webinars or future webinars, so we go into those in a lot more detail. I'd say that for E2, the EB1A is not that common to move to. People, I think, tend to move more to NIW. We have done a few, but I think people tend to move more towards NIW if they are moving. And then we might use some of the EB1A criteria for NIW, but yeah, I think that tends to be one we see more. The another kind of area which is interesting is diversity lottery, right? So we have had many E2 visa holders. I think we generally have one a year. So every year the government, you can apply in October, and then they announce in May they pick 55,000 random people. There are millions of people who apply, right?
Right.
But every year it seems we have at least one person on an E2 that wins the diversity lottery, and then they move to a green card based on that. So that's one way. And then there's sometimes our other like humanitarian based green cards. I can't really say that we've done one of those, moving someone from E2, but there are options like, for example, if you witness a crime, someone could move to, there's a visa, there's certain other visas for like VAWA, like violence, I think it's Violence Against Women Act. So there could be ability, someone that's on an E2 visa that's eligible under that particular criteria. So there are some other green card kind of humanitarian based options that could be relevant for people as well, that, if they're on a green card, on an E2.
Right. So we did have a question pop up just here. So can an E2 visa holder apply for an EB3 visa? Now, an EB3 is one of the employment-based categories, and that's where another company would sponsor that person, right?
Mm-hmm. It's
right.
It's a great question, because it's one aspect that I didn't talk about, where we do have, several people move to a green card, and that is the E2 visa holder, is the primary, and then their spouse has the ability to work, right? So she or he will be in the United States. The spouse will be in the United States, work, and they have the ability to work anywhere. So often she or he may get a job at a company, and then that company may sponsor him or her for a green card. And now, so the spouse now has ability to have their entire family join in that green card process, and that has happened a number of times, right? So the EB3, like if it's a spouse doing it, no problem. But if the question is EB3 for the the E2 visa holders business, it's not going to work for the reasons we talked about earlier, because you can't EB2 and EB3 for the purposes of sponsoring an individual and who you can sponsor, think of them as very similar. The only difference has to do with which category you're calling them. Are you calling them professional? Are you calling them unskilled worker? Are you calling, so they're yeah. So but it's definitely the rules with respect to like sponsoring yourself or family members are the same for both.
Right. So can someone apply for more than one type of green card or yeah, and there was another question where a husband applies for an NIW and can the wife apply for a lottery visa at the same time? So what is the answer to that?
Yeah, so people can apply for multiple types of visas. Like we have an individual who, she did E2 to EB5 and in direct, but then she's probably also eligible for national interest waiver. And
Right.
she already has the approval for EB5, but I'm not 100% sure that there's a full understanding that like EB5, it's so delayed, right? That there's still
Right.
so much more that has to be done in terms of timing and getting back her getting back proving the jobs and all these different things, that it may be beneficial just to do the EB2, because once you get that, you're done, right? Like with EB5, you get a conditional green card for 2 years, you have to come back. But it's a good example of she was at the time applying for 2 different green card categories, right? And that's completely
Right.
fine. And then diversity lottery doesn't impact anything. You can always, as long as you're eligible to apply for diversity lottery, because some countries are not eligible based on the fact that they look at how much immigration from that country has come in the last 5 years. So the countries roll on and off, but some countries, like if you're Canadian, for example, you're not eligible, like unless you have they're carve outs, right? But if you have a spouse that was born somewhere else and things like that. But you definitely applying for multiple types of green cards is completely fine.
Right. Okay, so the last question would be, is an E2 visa a dual intent visa?
Yeah, it's a great question. So it's not. It's officially not a dual intent visa. The dual intent visas are H-1B, L, and O. But E2 is not. I'd say it's about as the next closest thing, because the E2 visa does have wording in the regulations that says that you're not required to maintain a home in your in your home country. Which others suggest that that's required, like a B visa and things like that. And also they say that generally speaking, what will be sufficient in that regard is just a signed document that says that you plan to return to your home country. So it's not a dual intent visa, but it's about as close as you can get. But you do have to be planning is key when you're moving to a green card, because you don't want to be in the middle of a green card process and have to renew your E2 visa, right? Because that's when you're going to, that's when you may run into difficulties if that's what's happening.
Yeah, so if a person applies for an immigrant visa, and for example, if it doesn't go through, would the E2 renewal potentially be at risk?
It could, yeah, it could.
Yeah.
So a lot of the time, I just had a consult yesterday, and the consult was for national interest waiver. And the person was, we were talking, and I said to her that, we were talking about filing the I-485 petition because she's in the US right now and she's going to school. And I said, well, I think in your case, I think that if we did the I-140, then we would not file the I-485 petition for you, because we tend to only recommend that if the case is like a slam dunk case,
Right.
or if there are other timing issues where the person needs to stay in the US or whatever, something like that. But in this case, where the case would be, it could be a lot more challenging, or because these are, at the end of the day, these are subjective petitions, right? So it's not and the government doesn't post EB2 NIW approval rates. Unfortunately, they post EB2 approval rates, and those include perm, and so
Right.
it's hard to tell what the actual approval rates of NIW petitions are. So and not that the approval rates are necessarily going to guide. However, they're interesting to, I think they're interesting to look at. But so yeah, but one of the reasons I was giving her that advice was because we don't want to, whenever you file, the more you express the intent, and I think the other kind of important thing is expressing the intent to want a green card is not a problem. By law, it's not a problem. What is a problem is expressing the intent that you plan to come to the United States and adjust status. That's an issue,
Right.
right? So, but often that distinction, that subtle distinction, gets lost on border patrol, right? Because they're not like us lawyers who were well, the law actually is that you can absolutely have the intent to get a green card. What's prohibited is to have the intent to enter the United States and adjust status when you're on a non-immigrant visa. That's not dual intent. So that's but part of that is if someone just files the I-140 and then indicates on the I-140 form that they plan on consular processing, we believe that the risk associated with that impacting a future immigration petition is minimal, right? Like in terms, I always put these in terms of what would I do if it were to be me? I would be fine filing an I-140 petition saying on the I-140 petition that I'm consular processing, even if it was a weak petition, if it was denied. And then the other way you kind of, the advice that we'd give to people is, in that particular case, we may suggest petitioning through an entity. Right. So that even further dilutes because then they're not even the petitioner. So on future immigration petitions, if they're asked, have you ever been denied a petition, they don't even have to say yes, right? Because they weren't denied. Their company was denied, right?
That makes sense.
So it's kind of like we're always kind of thinking about what could happen, in the future or whatever, so to give people the most amount of options or whatever, so that they but if someone just files the I-140, I don't think that's so much a problem. But if they file the I-1, it's not zero risk. I think there's some risk, but I think that if they file the I-485, that's a clear indication that they were planning on adjusting status, right? So it's hard to, at that point, argue that, well, I, just filed it because I wanted to stay in the U.S. and things like that. So it's always something that we're considering.
Right. Very, very important consideration, whatever the type of green card someone may want to apply. Yeah, so thank you so much for your time, Ian. That has been very, very informative, and I'm sure a lot of our audience got something they learned out of our session. There were a lot of specific questions for various types of different visas, such as H-1B, the L-1. Yeah, please do feel free to schedule a consultation with us. We offer 30-minute consultations. And also 1-hour consultations where we can look in detail about your case. And please do check out our YouTube channel and our webinar list, because we do have dedicated webinars available for all of these types of visas. So yeah, thank you so much, everyone, again, for coming and being here. And I hope everybody has a good day.
Great. Excellent. Thank you very much. Thanks a lot, Jade. Thanks, everyone. Take care. Bye-bye.